So once that DNA test comes back negative, is that when I would go ahead and put the other father, or can I go ahead and start that process since we already know?
Yes, sir, I'm right here.
Thank you. And try to find a spot and don't move around because I don't want you to lose that cell signal, sir. Okay? Here we go. All right, folks. This is Bell 25 DFAN 352,262. This is in the 264th Judicial District Court of Bell County, Texas. As in the interest of early minor child, non-custodial party is Jakari L. Early. Custodial party is Marche D. Green. And this matters before the court on a original petition and suit affecting parent-child relationship with an announced paternity. The court will note for the record that both parties signed requests for hearings, which pushed them properly before the court without any service citation. And so at this time, we can go ahead and proceed at this point. And I'll ask the state for an opening to tell the court what the state's requesting we do here today. And I think my assistant explained this might be the case. I'm thinking it is. I want to confirm that this may be the one dealing with private DNA. So at this time, Mr. Welch, I'll let you go ahead and proceed. Thank you.
Today we are going inside a tense courtroom moment where a paternity case is about to unfold. The judge opens the session, calling out the case details and parties involved, setting the tone for what's clearly not an ordinary hearing. As the courtroom settles, every word feels heavy with anticipation. You can sense the mother's uncertainty and the father's quiet tension while the judge prepares to dive into the facts. What starts as a routine call instantly feels like the beginning of a life-changing revelation.
Correct, Your Honor. This is the case with the private DNA. So there's an acknowledgement of paternity in this case. It was already filed with the court, and the state asks the court to take judicial notice of it.
All right, it's attached to the pleadings. Let me see.
Yes, Your Honor.
Okay. All right. So not very thick, so. All right, yes, the court will take judicial notice of the filing of exhibit number A with the original petition that shows an announced paternity entered into and signed off on by the parties back in, looks like, October of 2020.
Thank you, Your Honor. So Jay understands that the parties apparently, or at least the father, Mr. Early, and the child, Jakai Early, they did a private DNA test. It was through the DDC. It looks kind of like ours. Apparently in Ohio, through any lab test now, that shows that DNA is negative. Now, Your Honor,
is it a dual draw or just a parental draw? I'm sorry,
All right, guys, now things get serious. The state steps in and confirms that a private DNA test was already done, and it reportedly shows the alleged father isn't biologically related to the child. The judge listens closely, weighing every word as the attorney explains how the test came from a private lab and not through official court channels. The atmosphere tightens. This isn't just about science, it's about truth and legal credibility. Everyone's waiting to see if the court will accept or reject this evidence that could rewrite a family's future.
Father draw only.
It's a father only.
Okay. All right, you may proceed.
And Your Honor, the reason I didn't, offer it or put into evidence is because I didn't want to get the docket confused. And I think they all agree that it's there anyway. So, Your Honor, the state has to object to the ordering of DNA, which is what Ms. Green and Mr. Early would like.
Right.
But I'm not going to strongly object, Your Honor.
Well, and the court's always going to do what's in the best interest of the child. Its best interest is the child to know who the child's father is. So I'm going to go ahead and grant the some brand new DNA testing. Obviously, I want mom drawn, I want the child drawn, I want dad drawn. But until then, I'm just going to do a DNA test. I'm not going to set up any temporary order, and we're going to get a chain of custody that gets us through all the legal requirements. And in the interim, ma'am, if you can get with the state, back with the state, with who the proper party might be, we can go ahead and start getting. They can start getting the necessary paperwork filed. So at this time, Mr. Early and Ms. Green, I'm going to go ahead and grant this brand new paternity test on this because this isn't your child's best interest for me to do so. and we'll get it set up and get y'all reset probably somewhere 6 to 8 weeks out and get that results back. And if it's still the same, then obviously we will find that Mr. Early's not the father and move on from there, ma'am. Okay. I'll start with you, ma'am. Ms. Green, any questions?
So once that DNA test comes back negative, is that when I would go ahead and put the other father?
Here's where the real turning point hits. The judge takes control, declaring that the only way to truly serve the child's best interest is through a brand new official DNA test. His words cut through the uncertainty, making it clear that the court values accuracy over assumptions. He demands all parties, mother, father, and child, be tested properly. Then, in a moment of levity, he jokes about AI making him a Dallas Cowboys draft pick, easing the tension for just a second. But beneath the humor lies the gravity of truth and justice unfolding in real time.
Or can I go ahead and start that process since we already know?
That's probably you can already let the state know who you know the father is, and they can start getting ready. Because again, this is if you recall, this time it probably took 2 to 3, 4 months for this to get to court to begin with. So let's get a jump on that one, because we know we've got a pretty good idea that's going to come back negative. But again, folks, ma'am, I've been all last week I was fooling around with AI, and I can get AI that shows that I was the #1 draft pick for the Dallas Cowboys in 1975. Okay, and I guarantee you I was not. All right.
Okay.
So yeah. So anyway, let's go ahead and get that set up and get the chain of custody. They'll get us to point A from point A to point B. And Mr. Welch, if it's not against y'all's policy to start getting that information together so we can get this because like I said, the child just matters. But now he's going to be 3. He's going to be 2 in October. So yeah, let's try to get this going where we can get the right party in here. All right.
Yes, Your Honor. And ma'am, I don't know if you already sent this to you, but we'll send you a form, attorney information gathering form, and you can give us information about the true biological father if Mr. Early isn't the father. So we'll get that going joint, and then file a new pleading, I guess, with the new father. Probably. All right, and then Your Honor, for the reset date.
I see something about is Mr. Early still in Ohio?
No, sorry, I don't mean to interrupt, but no, sir, I never took the test in Ohio. I believe that's just where they.
Oh, okay.
I don't know yet.
Where are you located?
I had the test done in Harker Heights, Texas.
Okay, yeah, I use the same facility you did. Both of y'all are local, so
Yes.
Mr. Welch, look at setting this one out about somewhere between 40 and 45 days and 60 days, because they're both local. We get that draw done ASAP and get that one back before the court.
Yes, Your Honor. All right. So, Ms. Green, Mr. Early, just wait in the breakout room. Someone will send you a DNA order with the reset date and the Zoom code. And then, assuming the test is negative, then we'll probably do an order against paternity for Mr. Early or something else like that.
Yeah, I can find it that he's not dead. So yeah, it's not the first time this has happened. So and Mr. Welch, I'm not sure if y'all still able to do that. If y'all can right now check when to see the appointments that can be made locally for DNA testing, maybe get that set up today before these folks get out of here. Okay.
Yes, Your Honor. And one of our DNA experts will come and talk to you. And she'll go through the ropes.
All right. See, back in the good old live days, they would be sitting here right in the courtroom, so we can get that done before y'all even left. So, but hopefully we still can do the same thing online. All right. All right, folks. I'll go ahead and let the state get y'all set up. We'll see y'all in about somewhere between 6 and 8 weeks, and we will hopefully conclude this correctly. And like I say, ma'am, get started on the right person. All right. And I'll start. I'm sorry, Mr. Let me give you the opportunity. You have any questions, sir?
No, sir.
And Ms. Green, do you have any other questions, ma'am?
No, sir, I don't.
All right. Anything else, Mr. Welch?
No, Your Honor. Thank you.
All right. Let's get everybody back into a breakout room, and we'll get you folks all the information y'all need. And then after that, y'all free to go. Okay. Thank you very much, and we're off the record.
Thank you.
All right. Let's move y'all away.
The hearing begins to wrap up, but the intensity doesn't fade. The judge lays out what happens next: official forms, new test appointments, and a reset date for the results. Both parties listen carefully, aware that the next few weeks could redefine their lives. Every instruction is methodical and precise. The court wants no mistakes this time. As the judge dismisses the hearing and takes it off record, one thing is clear: the next DNA result will either close this chapter or open an entirely new one. Don't forget to like this video, subscribe to the channel, and we'll see you in the next one.